thrilled to be speaking with Anne-Marie. She's one of my heroines. I have utmost admiration for Anne-Marie, for everything she stands for, everything she says, and she tells the truth with forthright courage, no matter what price she has to pay for doing so. So it's a privilege. I'm here to support her, and that's the way around it should be. But thank you again for having me. I'd just like to begin, if I may, by introducing myself a little more informally, but in a way which will explain perhaps why it is that I have come to be involved in this private members' bill to which you have referred. Whenever I have to introduce myself, all I ever say about myself, and it is all I do say about myself, is I am indeed a nurse and a social scientist by intention. That's what I thought I was doing in my life. A baroness by astonishment. If you want a seat, there's a spare seat in the front row, kept especially for you. And I say baroness by astonishment. I wasn't into politics. In fact, I must have been, I don't much like politics, and certainly party politics. And I was so much not in that world, I was actually the first baroness I'd ever met. And you wake up one morning and see a baroness look at yourself out of the bathroom mirror. It takes a bit of getting used to. But you say to yourself, well, how can I use this huge privilege? Because obviously privilege it is to be able to speak in one of the houses of the British Parliament, and privilege brings responsibility. And the idea came to me, actually being able to speak in one of the houses of the British Parliament is a wonderful place to be a voice for the voiceless, to speak for people who cannot speak for themselves. So, it was a long time ago now, it still seems unreal. But anyway, way back in the 1980s, one of the very first initiatives I was involved with was, some of you may be old enough to remember it, but way back in the mid-80s, the first private members' bill I was involved with was to try to deal with that barbaric practice of female genital mutilation, FGM. And I worked with two other peers, and I was very young and junior in those days, so I was the junior member of the trio. But we did introduce legislation way back in 1985 to outlaw FGM in this country. And I'd seen it for real in countries like Sudan, and it's not a thing I would wish on anybody. Well, that was 85, that law was passed. I did a bit of homework earlier this year, and there are over 65,000, it's estimated, women and girls suffering from FGM in this country. Not all carried out in this country, but either gone abroad and had it done, or been done here, or come with it. And there's not been a single prosecution. 65,000 and 30,000 are currently estimated to be imminently at risk. Still not a single prosecution. But one has to continue to speak up and speak out. My work then took me increasingly abroad to work with people trapped behind closed borders, and my small NGO Heart focuses especially on people trapped behind closed borders who are out of reach of major aid organisations. Because the big aid organisations, all the respectable names you all know, like the UN, can only go places with the permission of a sovereign government. If a sovereign government does not give permission to the big aid organisations to reach its victims, they can't go, and so those victims are left unreached, unhelped, unheard. And that is why I established my small NGO Heart, spent a lot of our time crossing borders illegally and completely shamelessly, to be there where it's at, with those victims of oppression and persecution trapped behind those closed borders. I go back tomorrow to South Sudan. I was in Sudan many times during the war against the South, a war in which 2 million were killed and 4 million displaced. And every month Khartoum issued a list of airstrips open to the UN and the closed airstrips. I went 30 times the closed airstrips. Khartoum did not love me, gave me a prison sentence for illegal entry. Thank you for having a convict in your midst. You're extremely inclusive, and I'm very grateful. But I do return tomorrow. But increasingly, as my time has become involved with those issues to do with human rights violations, and particularly the issues related to women and girls, I also became involved. There's a seat down the front row. Do come in the front. Yes, we'll show you up to Susie then. Thank you. I was invited by organisations whom I've unbounded respect, like ICRO, the Ukrainian Code of Women's Rights Organisation, One Law for All, and I became increasingly uncomfortably aware of the number of people in this country suffering from gender-related discrimination and how much they are suffering. Now, I have enormous respect for conferences. Anne-Marie's got a publication coming out which is going to be of enormous significance. We need those. We need the truth on the record. We need the evidence with which to try and challenge policy, to change policy. But the most important place, perhaps, for effecting change, of course, is in Parliament. And I decided I could no longer sit on those posh red benches and be aware that out here in this country, so many people are suffering in so many ways, and the thing that brings us together this evening is the religiously sanctioned gender discrimination, and also, as is so much been associated with the growth of Sharia courts, Sharia law in this country, the way that in itself is also, that parallel legal system, a threat to the fundamental principle of one law for all. So I began to think I've got to do something about it. It's uncharted territory, so I'd love to share and listen and learn from you how we can take this matter forward most effectively. Can I just say, can you hear me all right? Yeah. If you don't want to, if you want to and you can't, do let me know. If you don't want to, it doesn't really matter. But no, so I don't want to deafen you either. Am I deafening you by speaking to you? I've just got that. Thank you. Oh, you're such a therapist. Thank you so much. So I introduced, way back now, 18 months ago, a private members bill. I've got a copy and having email copies to anyone who might like to see copies of it, but to try to address these twin issues of religiously sanctioned gender discrimination and the threat to that fundamental principle of one law for all. Now, I say the bill is actually strongly supported by many Muslims, and particularly by many Muslim women's organisations such as Inspire, as well as by ICRO and the Henna Foundation, Karma Nirvana, British Muslims for Secular Democracy, the National Secular Society, and One Law for All. And lovely to come and share with you tonight, so thank you for inviting me. What I would like to do briefly is to outline the provisions of the bill first, and may in so doing emphasise I am not anti-Muslim. I'm deeply concerned that it is many Muslim women who are deprived of enjoying their full legal and civil rights under the law of this land. And I should also point out, if women from other faith traditions experience comparable or any kind of similar problems of systematic discrimination, like some of the extreme Orthodox Jewish members of the community, the Hasidic Jews, then the provisions of the bill would also apply for them. The bill does not actually name any particular religion. But the problems which have come our way, and which we feel is essential to highlight, arise because of the systematic discrimination imposed by the Sharia courts in this country. And that many women believe that those Sharia courts are real courts and do not know that they have other rights under English law, or they don't know the pressure that's put on them by their families, their communities, not to seek rights outside their community. Just give two examples of the kinds of problems affecting women in this country, and the examples are legion. These are just two emblematic examples. I've met these women, I've sat with them, I've seen the physical manifestations of their distress. We've wept together. One had suffered such severe domestic violence that she was hospitalised. She was pressured by her family when she was in hospital, and she was really, brutally maltreated. She was pressured by her family not to seek help from social workers or the police, because that would bring shame on the family and shame on the community. That honour-shame spectrum is a massive pressure. When she'd been discharged and went home, she went to the local Sharia court or Sharia council and was asked for help. She was told she had to return to her husband, because not to return to her husband would again bring shame on the community. So she did return to her husband. She suffered more domestic violence. Then her husband divorced her. I'm sure you're aware that under the Sharia traditions, the man can divorce the wife extremely easily. In some variations, just says, I divorce you 3 times, and the woman is divorced. It's not the same for the women. They have to go through various procedures and requirements which may vary with the different imams and Sharia courts. Well, he divorced her, so she was left a divorcee. He went back to his country of origin and returned with a second wife. Now, this lady is a devout Muslim. She really wanted a religious divorce to enable her, in terms of her religious beliefs, to remarry in accordance with her faith. But the Sharia court she went to demanded a marriage certificate. Well, her husband's family kept the marriage certificate. She went back to her ex-husband and asked for the marriage certificate. He said, oh, it's back in our country of origin. So her family in country of origin went to his family to ask for the marriage certificate. They retaliated by beating up her younger brother because she was bringing shame on the family by asking for a divorce. Well, 7 years later, this devout and desperately lonely Muslim woman has still been unable to obtain her divorce and therefore unable, within her own religious convictions, to remarry. Secondly, very briefly, a Muslim widow wanted to remarry. She went to the Sharia council or court, a widow, and asked permission to remarry. She was told she had to obtain the permission of a male relative. Well, she didn't have a male relative in this country, and she said she didn't. So the Imam said, well, you've got to get permission of a male relative. So she had to travel to Jordan to obtain the written permission of a 7-year-old boy relative in order to obtain her the permission to remarry in this country. And I've seen that written permission in childish Arabic. What humiliation. Britain today? This is happening in Britain today. And it's not surprising that another young woman complained to me with a great deal of passion. I feel betrayed by Britain. I came here to get away from all this. The situation here in Britain is worse than in my country of origin. I think you let that situation develop in this country, for women in this country, made our suffragettes, I think, will be turning in their graves. Other examples concern children. Under Sharia law, you may know a father who divorces his wife may claim custody of his children once they reach the age of 7. This gender discrimination violates the fundamental legal principle in this country that custody should be determined according to the best interest of the child. Under UK law, children's interests are required to be the final determinant in matters affecting them. Yet, there have been many cases under Sharia law, reportedly, where women are forced to give their husbands access to their children, even where British courts have ruled they should have no such access because it would not be in the interest of the child because of a history of violence. And I'm going to leave detailed discussion of this issue and others to Anne-Marie because she is the real expert in this field and she speaks and writes so authoritatively on it. So I'm going to return now, if I may, to a very brief overview of the bill and ways in which it seeks to address some of these problems, including those affecting women and children. The first fundamental concern of the bill seeks to address that development of the parallel quasi-legal system based on inherently discriminatory principles. This may involve proceedings operating under the terms of the Arbitration Act, or it may involve less formal community forums for resolving disputes. While some operate in ways which are not problematic, others give cause for the second and related concern that many women suffer from gender discrimination in these courts. This discrimination includes, as I already mentioned, the unequal access to divorce as between a husband and a wife. The wife may have to go through all sorts of procedures. I've just mentioned a couple at a Sharia court or council to obtain that divorce, but the husband has been able to obtain it just so easily. It also includes tolerance of certain forms of domestic violence. They clearly specify what kind of domestic violence are okay. They condone or they authorize a man's right to polygamy, to inequality between men and women with regard to child custody, which I mentioned, and inequality with regard to inheritance provisions. It even affects rules of evidence, since under Sharia law, a woman's testimony counts for half that of a man's. It's quite interesting. I was debating in Women's Hour after the first reading of the bill the first time round with an extremely sophisticated woman solicitor, and she operates both Sharia law and also English law, and she is an extremely competent lady. And we were debating, and we got to this question of the inequality with regard to women's testimony in a court of law, that it requires 2 women to give evidence where 1 man will suffice. And she, in her passion, said, over BBC Women's Hour, I was delighted to say, Radio 4, whatever it is, she said, well, of course you need 2 women. Women tend to get so confused. That from a very intelligent, able woman barrister, solicitor in this country. She know how deep these things go in the psyche. Well, anyway, let me make clear, the bill does not interfere in the internal theological affairs of religious groups or violate the fundamental principle of religious freedom. Freedom of belief, if people wish to submit voluntarily to the rulings of any body, religious or otherwise, even if been surrendering their rights under English law, they are free to do so. There's nothing compulsory about the bill in terms of infringing people's rights if they wish to adopt them voluntarily. The bill does not force them to give up religious law or abnegate conscience in favour of the law of the land. The bill also recognises existing legally sanctioned forms of arbitration, including Muslim arbitration tribunals, or MATs, and various forms of mediation available in religious or secular contexts. The bill will not affect the continuation of these provisions or their growth in accordance with the law of the land. It might be helpful if I just put some flesh on the skeletal outline by highlighting some of the specific concerns and how the bill tries to address them. First, the Arbitration Act of 1996 facilitated the establishment of arbitration tribunals. Some operate according to Sharia law. They allow parties to settle certain civil, largely financial disputes in such a way that the arbitration awards can be enforced in UK courts. However, there is a concern that even when these tribunals are operating within the terms of the Arbitration Act, some are still practicing sex discrimination. For example, a tribunal in Nuneaton, adjudicating on an inheritance dispute between 3 sisters and 2 brothers, in accordance with Sharia law principles, gave the men double the inheritance of the women. And that is fairly standard practice. It's inherent Sharia provisions, people correct me if I'm wrong. Some arbitration tribunals also appear to act outside their legal remit, and this is very worrying. For example, there have been reports of MATs dealing with grievous bodily harm. An investigation by Edna Fernandez, reported in the Daily Mail on July the 4th, 2009, I quote, "Scores more imams dispense justice through their own mosques." And that, quote, "Sharia is being used informally within the Muslim community to tackle a plethora of crime." A parallel legal system. The Arbitration Act does not empower MATs to arbitrate on criminal matters, and surely it must be unacceptable to condone a situation where non-Muslim offenders get a criminal record, but Muslims do not, because they go to an alternative quasi-legal system. My bill would make it a criminal offence to falsely claim legal jurisdiction. Any person who purports to arbitrate in any matter which is in the jurisdiction of the criminal courts would be liable on conviction to a maximum penalty of 5 years in prison. That's probably the most hard-edged act of the bill. It's where the bill really has teeth. There's some seats in the front. Do come and fill in the gap. It's a bit like an Anglican church. Empty seats in the front. Thank you very much. Now, one report has estimated that there are at least 85 Sharia forums in the UK. As far as we can ascertain, the Sharia courts or councils keep scant records, have no right of appeal. There's nothing like the control over justice's appointment and conduct that apply in secular courts. Most do not operate under the Arbitration Act. Instead, they informally resolve disputes under what is loosely termed mediation. And as I've said, many women wrongly think these informal tribunals are real courts and submit to their rulings accordingly. Now, of course, my bill cannot solve every problem, but it does offer some opportunities for redress and protection. For example, where a negotiated agreement is formalised in a consent order, the bill would make it easier to set aside the consent order if it was reached under duress, or where a party's consent was not genuinely informed. For example, where a woman was not aware that you would have had different rights according to our UK civil law. That's point number 1. Point number 2, the bill will make it easier for women who are unhappy with discriminatory rulings to apply to the courts to have them overturned on the grounds of gender discrimination. For example, you'll probably be aware, and I have to do a lot of homework on this, but under arbitration proceedings, if a decision is reached with mutual consent from both sides, as I understand under UK law, then that becomes legally binding. What this bill would do was, if a woman retrospectively realised that the ruling was made on the basis of gender discrimination, then she could apply to have that contract unravelled and reconsidered. It means, of course, she'd have to have the know-how, she'd have to have the access, and she'd have to have the freedom from her family or community to do so, but at least it would allow some unravelling of an inherently discriminatory ruling. The bill also strengthens the power of police and courts to protect victims of domestic violence from coercion and intimidation. We give the same protection to victims of domestic violence for women suffering domestic violence At the moment when they go to their Sharia courts, again and again and again we're told, the imams say to them, you must go back to your husband, you have to put the family first. And the serious consideration to their needs is downplayed alarmingly often. And then, of course, when they go back to their homes, go back to their communities, the pressure on them not to seek help outside the family, because it would bring shame on the community, is overwhelming. And you can imagine trapped in those Taliban-like communities, increasingly growing in some of the cities. It's almost impossible for those women to get out and seek the help they need. And one of the ladies I spoke to said, yeah, but my husband, unlike so many other men, when they go back to their country of origin, they deliberately go to rural areas and they find a young girl who's probably illiterate in her own country and bring her back to this country. There's no way that a young girl vulnerable in her own society, doubly vulnerable in a strange society, trapped in one of these closed communities, is really ever going to have the know-how, or the confidence, or the ability to get out and seek the rights, the redress, the protection that she needs. If anyone has not as yet read The Imam's Daughter by the pseudonym Hannah Shah, I really would recommend reading it. May I say that the author of that book, it's a biography, whom I know very well. He came with me on many visits to Sudan. He's got tremendous integrity. He's a wonderful writer, and I would trust every word in that book. And it's called The Imam's Daughter, Hannah Shah, and it is a spine-chilling account of the experience of one young girl in this country. I wanted to speak to her, and off the record, secretly at a place of my choosing, no way of identifying, she is still too terrified to speak. That level of intimidation in our country today, we've got to do something about it. The bill would also strengthen the power of the police and courts to protect victims of domestic violence. The point I wanted to emphasise there was the Imam's daughter. That young girl from the age of 7 was abused by her father in the cellar of their house, again and again, and violently abused. And then one aspect of the book, which we've heard from other people too, so it's not a one-off, is that at one time when she was so desperate, that young girl, when she was at school, did actually go to the school social worker for help. That afternoon she arrived home hoping there would be some help, and to her horror, she found a culturally compliant social worker to whom the case had been referred because it was culturally compatible, sitting on the sofa just laughing with her father. And she realised that life was going to be infinitely worse for her after that. So we have here this whole business about culturally, and Anne-Marie speaks wonderfully about this, about the politically correct, the culturally acceptable, and so often it just leads to more entrapment and more imprisonment for people trapped in these communities. The bill would also enhance the public sector equality duty, for example, require police, social workers or healthcare workers interacting with Muslim women to explain to those women what their legal rights are, how they're diminished and their marriages are recognised only under religious law and not civil law. Many women have described again and again how in their community or by their husbands-to-be they're discouraged from having a civil as well as an Islamic marriage. And that gives rise to all the grave problems, and especially women, as often happens, the husband, as I've already mentioned, who subsequently divorces his wife, leaving her and her children with no civil rights whatever. There's a great vacuum here. Many women who do seek redress through their imam are subject to multiple disadvantages. The English language may form an impenetrable barrier for many. And I was speaking actually recently to a judge, and she said that she has actually heard, or friends of hers have heard, interpreters in those courts deliberately misinterpreting what is being said. So we have the problems of interpretation, linguistic interpretation, and that's something which, again, has been identified and is capable of adding to the abuse. Women who are isolated in non-English speaking communities are completely subject to their husbands, just as English women were a century ago. They will have no access to, no capacity to seek justice. If a woman can't speak the language, she cannot get independent advice. If she's fettered in a loveless and violent marriage, then caught in a culture which accords precedence in virtually all matters to the husband, life will be profoundly difficult for that woman in Britain today. The psychological consequences of that situation are well known. Such women have no concept of their legal rights. They may be cowed and beaten into submission to Sharia law, under which there may be no redress for them, and their testimony, well, as I've said, not be accorded the same value as that of men. That applies particularly in cases of alleged rape. It requires 4 men independently to give testimony to a rape claim. It is indeed a very lonely place for a woman of whatever age to find herself. And many of these women find themselves locked in those violent or polygamous marriages when they had thought they were entering a monogamous union registered under UK law. And as I draw to a close, one or two other problems. A real problem of intimidation, often on the basis of strong cultural commitment, which I've already mentioned, there's a concept of honour and shame. So many women to whom I've spoken describe vividly the pressures put on them not to seek legal redress, police protection, or professional services outside the communities, as it would bring shame on their family or the community. One young Muslim woman who came to see me, having suffered from tremendous intimidation in an attempt to force her into a marriage, was so terrified, in my particular flat in North London, that when she was waiting for someone to come and collect her, she hid behind a tree. To hide behind a tree in Britain today, you're so terrified of being seen. This intimidation is real, it's intense, and it's heartbreaking. Well, there are also powerful and poignant, well-documented accounts of intimidation in which girls and women are subjected. I don't know if you've seen the spine-chilling documentary, TV documentary, Baroness, A Love Story. That is, if you get a chance to see it or to download it, do. That's poignant. A young Kurdish woman was attempted to be forced into a marriage. She didn't want it. She knew that threats were building up in her family, her community. She knew she was actually facing possible violence and death. 5 times, I think it was, she went to the police, and the film actually shows the recordings of her interactions with the police when she went to seek help, and there she is, obviously terrified, wringing her hands in a state of terror. The police did not help, and she was eventually trapped. She was invited, I think, to her grandmother's home, and she was gang raped by her brothers and strangled, I think, with steel. I mean, it's a horrendous story. To be fair, there is a wonderful policewoman Caroline Good, who had tried retrospectively, too late to help Baroness, but to try to get justice, and did indeed succeed in achieving the extradition of 2 of the family members who murdered her, who fled back to Iraqi Kurdistan, did get them extradited to face justice in this country, but too late to help Baroness. The evidence is there, it's around. So Baroness, B-A-N-A-Z, Baroness, A Love Story. And it's heartbreaking. Be prepared to have your heart broken. Well, in conclusion, I must emphasize these are the kind of things that make me passionate, and one would come and share the pain and the passion with you tonight. The Private Members Bill is just an initial attempt to try to provide help and support for citizens of this country, and especially those vulnerable women and children who are currently suffering in ways which are utterly unacceptable. The bill cannot do everything, may need much amendment, but it is an attempt to highlight the problems and to initiate some help. I was very pleased, I'm happy to send you a copy if you wish to see it. When we had the debate for second reading in the last parliamentary session in October last year, the bill, I was amazed, we had a lot of peers' briefings, and it was very helpful to enable peers to hear from some of these women themselves. It received widespread support, I'm happy to say, from members of all parties and different faith traditions, and none. On the Conservative side, Lord Mackay of Tashfan couldn't speak in the debate because the government was put it on late on a Friday afternoon, and he couldn't speak, but was very supportive. But other Tories spoke. Alex Carlisle, maybe known to many of you, a wonderful QC who's passionate on human rights. He's very supportive. Lord Dalakia heads up Lib Dems as a Hindu. On the other faith traditions, Lord Singh of Wimbledon, a Sikh, spoke very powerfully and said we had the complete support of him and his community. And there was a lovely Labour peer's name, I'm afraid I can't remember at this moment, who used to head up ACAS. And she was extremely dynamic and also very humorous, but passionate in support of the bill. The only disappointment was the government's response, which argued it's not necessary because all people in this country have access to their legal rights in this land. All I can say is, I wish. My conclusion was, and still is, there is an enormous chasm between the de jure position espoused by the government and the de facto position of the reality of too many vulnerable women and children suffering in this country, who's going to speak in just a moment. I cannot for 1 minute pretend that Bill's got everything right, or that he can put everything right. But unless we can have genuine discussion on issues which I believe must be of concern to all who care about the rights of women and children in our country, in ways which they can protect it and promote it, then I fear we've either become a society inhibited by intimidation. Simply because you can't do that. You'll be accused of being Islamophobic. Well, I'm sorry, the truth has got to take priority over false accusations. Or there's a risk we'll become a society which has abnegated its responsibilities to care for all its citizens. I don't think we have become that society. Your presence here tonight proves we haven't, but there's a lot of work to do. So thank you for letting me share a little bit of my endeavours in this area.